start the function right now. It was supposed to start at
on the new income tax bill 2025. I now request Shri Mahavir Singh, Vice President Delhi Zone, to come to the dais, accompanied by the Chairman of the Technical Session, Shri Saurabh Saparkar, Senior Advocate, Shri Raman Chopra, Principal Commissioner of Income Tax, Central Circle, Delhi, Shri K.K. Chaitanya, Senior Advocate, I now request our Vice President Shri Mahavir Singh to introduce the speakers for the session. Good evening, everyone. Now we are going to start this session on new income tax bill 2025. For that, the chairman of the session, Sri S.N. Soparkar, Senior Advocate. No introduction is needed in tax fraternity. He is a well-known person. He is senior advocate, mainly practicing in Gujarat, but appearing all over India, even in Supreme Court. He is basically a chartered accountant turned advocate. And in chartered accountancy, he secured third rank in both intermediate as well as final examination. He has practice of over 4 decades and particularly specialization in tax and commercial laws. He is a legend, and I have opportunity to hear him for 4 years in Ahmedabad. And one more quality of his, that he is so humble and good human being. Another legendary senior advocate, Shri K.K. Chaitanya. He is a distinguished tax professional and senior advocate, having practice of experience of 30 years in taxation and law. Shri Chaitanya started his career at PricewaterhouseCoopers and Hindustan Lever Limited, and later he is also a chartered accountant by profession earlier and then turned advocate. Mr. Chaitanya, is correct? Yes. Yeah. In South India, he is appearing in almost all tribal benches and even Madras High Court as well as Karnataka High Court. He is a
prolific speaker, having lectured at IIM, ICA, and many other professional forums. And today he is on the panel. To represent the department, an IRS officer of 1993 batch, Shri Raman Chopra, who is Principal Commissioner of Income Tax Central 1, New Delhi, who is a mind behind the new Income Tax Bill 2025. Shri Chopra, a combine of technical, legal, and economic expertise, being a gold medalist in electronic engineers from Punjab University or Punjab Engineering College. Now as a Joint Secretary, Tax Policy in the CBDT. And he is holding this post from 2021 to 2025. And he is the main person in drafting this new tax bill and shaping 10 union finance bills. He led major reforms in areas such as virtual digital assets, online gaming, capital gains, and charitable institutions, while promoting voluntary compliance through updated returns and e-verification schemes. On global front, he represented India in tax policy, discussion with UAE, Qatar, OECD, IFA, and others, and is a member of Niti Aayog's consultative group on tax policy. Today only he told, and I also came to know that I appeared before him when I was in practice in Chandigarh, when he was ACIT, around some 98, 97, 99 or so. I was remembering one or two cases. He told that you appeared in many cases. Thank you, Mr. Chopra.
Thank you, Mr. Mahavir Singh. I now request, friends, this is the time to felicitate all our speakers and the chairman of the session. I now request Mr. Vijay Pal Rao, Vice President, Hyderabad Zone, to felicitate Mr. Saurabh Saparkar. Starting with a shawl. Stifel. And a small memento. With a plant. Thank you. I now request Mr. B.R.R. Kumar, Vice President, Ahmedabad Zone, to felicitate Shri Raman Chopra. With a shawl. The Stifel, the memento, with a plant, with our coffee table book which was released in the morning, with a plant. I now request Mr. D.R.L. Reddy, Vice President, Calcutta Zone, to felicitate Mr. K.K. Chaitanya, Senior Advocate. With a shawl. a steeple with a memento. And with a plant. Ladies and gentlemen, we have the topic for the day, salient features of Income Tax Bill 2025, which will be briefed by the speakers. But before that, I thought a small poem on the new income tax bill would fit that, so that given this poem in the mind, whatever the speakers tell us, we will be able to accept and understand it much better. The poem reads like this: a clearer code, a simpler way, the tax law enters a brighter day. With fairness, form, and thoughtful might, it brings old shadows into light. Income defined. This is a great thing. No room for doubt. Residency rules now firmly laid out. Digital paths and justice combined. A law for the future, reformed and refined. Thank you. Over to you, sir. I now request Mr. Mahavir Singh to call upon Mr. Saurabh Saparkar.
Good afternoon. Honorable Shri Mahavir Singh, Honorable distinguished speakers of the day, Honorable Vice Presidents and other honorable members of the tribunal, and friends. First of all, I am grateful for the confidence reposed in me to be a part of this session. I am not the speaker, and I am not going to discuss in great detail the finance bill. My role is to introduce and probably to conclude the discussion. So I'm going to be brief. If you want to look into the correctness, advisability, or appropriateness of a new legislation, you need to find out, first of all, the need for the same. What was the need? Whether or not the objects for which the new law is being brought in, does the new law meet with those objects? So let us see, why is it that we require a new law? Income Tax Act 1961, obviously as the name goes, was brought in the year 1961. We had become independent in 1947. We were essentially an agrarian economy. We were a country which was essentially looking at socialist model for the purpose of development. All big industries were being run by the government or in the joint sector. Small was beautiful was the mantra, and small scale industry was being promoted. We had serious problem of foreign exchange, and the rate at which GDP would grow would be around 3 to 4%. The Income Tax Act 1961 was therefore brought in to cater to the economy which was then in prevalence. But then over a period of more than 6 decades, we progressed. We progressed significantly. We have today, for example, an economy which is one of the largest in the world, third or fourth or fifth. We are likely to be third largest economy maybe in 2-3 years. Almost today it touches $4 trillion. As opposed to foreign exchange which was unavailable, We have now surplus foreign exchange. From industrial production being the basis of economy, today we are an economy which is essentially service sector oriented. Rate of growth exceeds 7%. Now, why am I going into the economics? Income tax laws must be the law which is made to cater to the changing needs of the fiscal health of a country. What was good then, does it remain good today? The law brought in the year 1961 is an archaic law, is a law which is too complex, too verbose. With the provisos below a section, take a standard section 1023C, with more than 20 provisos, and the problem of the provisos is that they are not numbered. So every time you are referring to 18th proviso, you as a council and bench as the adjudicating body has to go on counting 18th number to reach 18th proviso, unlike explanations which have number or subsections which have number. The whole law was absolutely unwieldy. On the lighter side, I did ask ChatGPT, how many amendments are brought in between 1961 and today in the Income Tax Act? It went on rotating, did not come up with an answer, said, I don't have an answer. So I went to Gork, the next. Gork did no better. He said, I have no answer. So also Gemini, it has no answer. How many times law is amended? We don't know. We know between 1961 and 2025, there have been annual finance bills or finance acts, and amendments every year would range from 30, 40 to a couple of hundred. Some section would go on being amended year after year, whereas some sections may not be touched for 3-4 more years at a go. But the whole law was a jungle of sections. Economy has changed, and therefore there is no doubt that you needed a fresh look at the law. What was good then has outlived its life, and nobody can quarrel with the proposition that we required the fiscal system of this country being looked from a slightly different prism, and therefore from a country which was in the stage of beginning its development, we have now reached a stage where we are one of the superpower or major economy in the world. We require a piece of legislation which would ensure growth of industry, growth of service sector, equality of income, so on and so forth. It is from this perspective we need to see whether or not the new bill addresses our concerns. At this stage, I am not entering into it. The two distinguished faculty over here, I am sure they are going to enlighten us on this. I reserve my comments, and I do have some comments, but I reserve my comments till the end, where I am, Honorable Chairman of the session says I am allotted 10 minutes time. So in those 10 minutes in a capsule form, I'll come up with my comments. With this, I hand over the mic to Shri Chopra and request him to take us to the journey. He is going to take us to the journey of how this piece of legislation is being brought in. Thank you very much.
Good afternoon. Actually, post-lunch sessions, as always, have one basic problem, the problem of sleep. I will try not to put you to sleep. I'll be short, or I'll keep on flipping between Hindi and English. I have learned that maybe that sometimes keeps people more awake. कुछ हिंदी ज़्यादा अच्छी जानते हैं, कुछ इंग्लिश ज़्यादा अच्छी जानते हैं, तो अगर आप फ्लिप करते रहें तो उनकी अटेंशन रहती है. That is my experience, so you can also try it. First of all, I would like to thank the tribunal, its president and all the organizers to actually think about this technical session because पिछले 60-65 सालों में इनकम टैक्स में जितना काम इस साल हुआ है in the tax policy division and the related persons along with that extended tax policy division, it has never happened. We've had a bill in July, 23rd of July, we had a finance bill. We had a finance bill on 1st of February. Then we had a whole income tax new bill on 13th of February. So normally a budget in itself is a big exercise. We are 24/7. I've been there for 10 finance bills. So I can vouch for that it is not simple. But there was a commitment which was given in July and we tried to fulfill it. And that is why it was important, and I sincerely appreciate that the tribunal and its president and its members have found it important enough to give it a session here. I will not be as technical as my friend Mukesh ji was in the morning. The session is purely factual from my point of view, और क्वेश्चन ऑफ फैक्ट पे आप ही सुप्रीम कोर्ट हो, हम सब जानते हैं, और इस करके मैं बिल्कुल लीगल नहीं रहूँगा. आई विल ट्राई टू रिमेन एज फैक्चुअल एज पॉसिबल. So where did it all start? But before that, what do we have today? This act was preceded by the 22 Act. सर ने कहा कि आज वाला एक्ट बहुत कॉम्प्लेक्स हो गया था और इस वजह से we required some change. So I delved into that perspective going back to 58, 59, when the Law Commission gave its report as to why a bill was required at that time. And we are all aware history repeats itself. I was very reluctant, but I would like to read the introduction of the Law Commission report of 58 with reference to the 1922 Act. I'll read one line. I didn't put it because मैं अपने इनकम टैक्स एक्ट को क्रिटिसाइज नहीं कर सकता, but still, the introduction, it starts from here. The Law Commission report on the 22 Act starts from here. There is hardly any act on the Indian statute book which is so complicated, so illogical in its arrangement, and in some respects so obscure as the Indian Income Tax Act 1922. That is what the act was at that point of time. 61 wala act us consequence mein aaya. There were two committees which were formed. They gave such reports, then redrafted it. It took time. It took about 5 years or so in coming in. But it came and came into effect from 1/4/62. Again, the requirements at that point of time were exactly the same as the requirements now. And in fact, the mandate also was very similar. Originally, now, once a law starts, as it was mentioned by the first speaker, कि income tax enable करता है economy को, और हर economic sector में कुछ incentive required है. गवर्नमेंट के पास 3-4 तरीके हैं इंसेंटिव देने के. एक डायरेक्ट इंसेंटिव का स्कीम है कि हम डायरेक्टली सब्सिडाइज करें कुछ सेक्टर्स को, उनको पीएलआईज दें, उनको सब्सिडी दें. दूसरा सेक्टर है कि जब प्रॉफिट्स हों तो उस पर एग्जेम्पशंस हों. ओरिजिनल फोकस वाज ऑन दैट साइड, that how do I reduce the tax burden. It gradually shifted in the last 10 years. We shifted on direct benefit schemes. But so be it. From 61 onwards, it went on happening. And as he said that ChatGPT failed, I sincerely appreciate that statement, that ChatGPT will fail. 64 finance bills were brought in, which resulted in finance acts. In the initial years, there were lesser amendments, then they crossed 100. About 4,000 to 4,100 amendments were there. 300-400 के लिए तो मैं ही रिस्पॉन्सिबल होऊंगा क्योंकि मैंने 10 बिल हैंडल किए हैं. But we cannot fault the government for making amendments. It's absolutely right that amendments make the section complex. He mentioned 1023C, there are 10 others. Where a principal section is there, principal section applies originally. और originally apply करता है, उसके बाद आप कहते हो from the assessment year beginning 1/4/22 onwards, this will be read as this. Then 23 onwards, this will be read as this. 153 subsection 1 gives me 6 provisos and I have to go to the 6th proviso to actually see कि आज timeline कितनी है. तो ये सब complications ना डिजायरेबल होके भी नेसेसरी हैं. एक पॉलिसी फ्रंट पे और प्रोसीजर फ्रंट पे दोनों के कारण अमेंडमेंट्स होती रहती हैं बिल में, एक्ट में. और स्ट्रेंजली इनफ देयर इज नॉट a single repository of an official income tax act at this point of time. It is just the taxman which introduces the Finance Act की amendments regularly in that. Law Ministry के मेरे friend बैठे हैं यहाँ पर, they would know that original income tax ही है, जो original bill है, original act है. Government publication और कोई नहीं है उस तरह की. That 298 section went on to become 819 sections. Why? Again, I said it was a constant evolution, but that evolution has made it very voluminous. That language has become very difficult for a common man to understand. I am unable to comprehend. I, as JSTPL, was even unable to comprehend some sections. आप पढ़े 158B सेक्शन है, 158A सेक्शन है, जिसमें असेसी अपनी ऑप्शन देता है कि मेरे को सेम क्वेश्चन ऑफ लॉ है अर्लियर ईयर में, तो मुझे वही. दैट गोज फॉर 174 वर्ड्स. दैट वन सेंटेंस इज 174 वर्ड्स. सो दैट लैंग्वेज वाज आर्काइक. एंड कंटिन्यूसली इन द लास्ट 5-6 years there has been constant criticism of this. Your act is very complex. And the second criticism was कि change तो आप करते ही नहीं हो इसको. So in that context, that kept on building over and over again on us in the tax policy division, in the Department of Revenue, and at last a decision was taken to undertake a review of the whole system. But this was not the first time. ओरिजिनली 86 और 91 के बीच में एक अटेम्प्ट किया गया इसको चेंज करने के लिए, न्यू बिल ड्राफ्ट करने के लिए. देन 1996 एन अटेम्प्ट वाज मेड. इन मोर रिसेंट टाइम्स 2009 में एक येलो बुक आई थी, यू वुड ऑल रिमेंबर, डायरेक्ट टैक्स कोड के नाम से. एंड दैट formed the basis of the bill which came in 2010, the direct tax code bill. And we were very close to introducing a final bill in 2013. The direct tax bill 2010 went to the select committee. The whole process, we went through the whole process. I was in TPL at that point of time also. But in 2013, the bill was not presented to the Lok Sabha again in the modified form. क्यों सक्सीड नहीं किए पहले बिल्स? उसका फंडामेंटल कारण यह था कि हमने बहुत कुछ चेंज करने की कोशिश की. We tried to reform the act. That is why I've written reforming the act. They tried to change everything, tried to introduce so many new things. और नेट रिजल्ट 2019 में भी बहुत सिंसियर अटेम्प्ट हुई उसको चेंज करने की. Again, we were very close to, we actually drafted a full legislation at that point of time. But कारण वही था, we tried to do too much. And that is why it just was resulting in nothing. Just going by the same logic, that since 2014, lot of changes were brought in. Lot of radical changes have been brought in if you see the government policy. कि हम exemption deduction की regime से आगे चल रहे हैं, current economy में कैसे promotion हो उसको देख रहे हैं, tax rates को हमने radically कम कर दिया, 30% से 22% corporate tax को कर दिया, which is a huge thing. and moving forward for new regime लाए, deduction exemption से दूर चले, promoting people to voluntarily opt for a regime which is simpler, trying to induce into people that adopt that portion of the act which is simple. 74% of the people opted for the new regime last year. We're expecting 95% to cross over this year. So the intention of the government was to make the law simple, either through substantively or consequentially pushing the people to a simpler regime. So going on all these logics, along with the incremental change required by economy, again resulted in the first problem itself, that my act, which was there, my statute, was becoming more and more and more complex. अगर 115 BAC भी सेक्शन आप देखें जिसमें हम न्यू रिजीम दे रहे हैं, उसके 3 पार्ट हो गए हैं रेट्स के लिए ही. उसका सबसेक्शन 1 है जो ओरिजिनल है 2.5 लाख से 5 लाख, 5 से 7.5, फिर सेकेंड ईयर 3.7 वाला आया, फिर अब 4, 8, 12 वाला आया. That will keep on going and growing. So we have to put an end to this complexity, or rather absorb this complexity into something new. And that was the intention. और जैसे जैसे sequential reform होते रहे तो बिग बैंग की रिक्वायरमेंट कम होती रही. जो DTC कोड 9 में आया, उसके बाद 17 से 19 भी अटेम्प्ट हुआ. इट वॉज नेवर मेड पब्लिक, बट देयर वॉज अ स्ट्रॉन्ग कंपोनेंट ऑफ बिग बैंग रिफॉर्म इन दैट, in both these bills. But here, since we had already gone through a sequence of substantive changes, now what was required was, it set the stage for simplification of the existing law. If you see, that is the basic background. That हम सारा कुछ already change कर चुके हैं. Based on what was being proposed as a big bang, we brought them bit by bit on this statute itself. क्योंकि 9 वाले में भी कुछ अच्छा था, 17 वाले में भी कुछ अच्छा था, उसको हम gradually लाते रहे इस बिल में. और अब हमने सेट कर लिया अपने आप के लिए एक टारगेट कि now we need to simplify the Income Tax Act. And this culminated in a firm commitment of the finance minister. It was never done earlier or prior to this. I'd again read that statement of the finance minister, that I am announcing a comprehensive review of the Income Tax Act. The purpose is to make the act concise, lucid, easy to read and understand. So हमारा focus सिर्फ ये 3 words ही हैं, concise, lucid और easy to read. That is the focus. And that is the mantra that why we succeeded this time. कि हमने कोशिश ही नहीं की बिग बैंग चेंज करने की, हमने फोकस किया कि वही का वही बिल हमने ईजियर लैंग्वेज में लिखना है. Income tax by itself is complex because human beings are complex. The components of income are complex. हम उसको simplify नहीं कर सकते, वो complex ही रहेगा, पर उसकी language easy to read, easy to understand होनी चाहिए. So that was the purpose, and that is why it has been brought in. Second commitment which the FM gave, again never before, was to complete the work in 6 months. A huge task. Anybody who's seen legislation would understand that even a section of 200 words takes a lot of time. You have to redraft it 3-4 times. It goes to law, they vet it, they give us suggestions, we do it again, then it goes back. Still errors remain. So legislation is not a simple thing, and doing 819 sections was difficult. And I would give full credit to the earlier Revenue Secretary, Mr. Sanjay Malhotra, and the present chairman, Mr. Ravi Agarwal. They really drove this project. Like a project management executive, driving this to finality. And that is why we could put it on in the Lok Sabha on 13th of February. now the drafting aspect, we needed some guidance on how it is to be drafted. So हमने दो कॉमन लॉ कंट्रीज को अपना बेस बना के, इंग्लैंड और ऑस्ट्रेलिया दोनों को ने स्टडी किया, उन्होंने अपने लॉज चेंज किए थे, एंड दे चेंज इट बाय इन सिमिलर मैनर, रिजल्टिंग इन सिंपलर लैंग्वेज. दैट वाज द फोकस. उनका भी यही फोकस था कि हम इसको सिंपल कैसे कर सकते हैं. बट what was different was they had a lot of time. You see UK's simplification of language lasted from 1994 to 2010, and original one statute was resulted in 5 separate acts in UK. तो वो 5 अलग एक्ट बने एक एक्ट से, और 16 साल लगे सिंप्लीफिकेशन के लिए. और सिंप्लीफिकेशन से हमारी वर्ड्स भी बढ़ गई यूके. Similar for Australia. Again, it resulted in increase of words. So यहाँ पर commitments different तरह की थी कि हमारा act पहले ही बहुत लंबा है और हमने उसको short भी करना है और simple भी करना है, which made our task even more difficult. But the end product, what was the end product from this exercise? I'll jump to the end product, then give you snapshots of how the changes have actually come in. And the speaker after me shall speak in detail about the nitty-gritty of the sections which he wants to highlight. I am on the process part itself. We had 47 chapters reduced to 23. Sections to 536 from 819. The word count has reduced from 5.12 lakhs to 2.6 lakhs. A huge exercise has gone in. And all the changes which were done on 1st of February were brought into the new bill which was introduced on 13th. So even that is a huge task. क्योंकि हर बिल बनाने की बहुत सारी स्टेजेस होती हैं. It goes up to the cabinet, gets approved from the cabinet, comes back, then it's to be drafted again, then it goes back to the FM for signature, then it goes back to the president for his assent, then it is introduced in the parliament. So that whole process and changing it after 1st of February was even required a lot of effort at that point of time also. How was the reduction done? Fundamentally, आप बहुत section पढ़ेंगे, पूरा section है. Subsection 1 says this, 2 says this, 3, 4, 5. Subsection 10 says this section will not apply to assessment year beginning on or after 1st of April 2004. That is still on the statute. इस तरह के एक नहीं बहुत सारे section थे statute पे, आज भी थे. 61 वाले हैं आज भी. So redundancy part was a major part. Initial discussions में जब हम करने जा रहे थे तो हमारा focus सिर्फ redundancy पे था कि redundancy, हम इसमें से redundancy हटा दें तो 30-40% word तो वहीं हट जाएंगे. So many sections are there which just the second section overrides the first section. The first section is not omitted or substituted. There again we had a lot of discussion with law. Over the years we have been having कि उस सेक्शन को omit कर देंगे तो उसका consequence ये हो सकता है. वो legal background में existing legislations, existing litigations में omission is different from substitution, and there's so many arguments to that. So we kept on adding, redundant provisions kept on increasing. So the first focus was remove the redundant provisions. Second focus was simplify the language. Shorter sentences, shorter sentences, shorter sentences. That was the focus. As I mentioned, एक section में 174 word है, एक ही section में, और वो section एक ही sentence है. In legislation, in archaic drafting, we do not have a full stop in any section, subsection. The subsection reads as a single sentence itself. In your normal writing, you do not write a sentence which is more than 25 words. But legislatively, when we are drafting, we are constrained by this logic, and we result in complex readability of provisions. So that was to be avoided. We split it into sub-clauses again and again. At everywhere you go through the bill, everywhere you will see that there are small sections, small sub-clauses. Of every complex section has been subdivided. कि आपको, मैं उसका भी example आपको दूंगा कि वो section किस तरह से improve हो गया. Then tables का बहुत major use हुआ है bill में. जिसने भी bill पढ़ा है, I hope most of you have read it. There is a lot of use of tables. Because I'll just have some water. Tables का extensive use हुआ है. Provisos, sir ने mention किया था, there were lot of provisos and explanations. Provisos and explanation एक भी नहीं है नए बिल में. Not a single proviso, not a single explanation is there. Notwithstanding पे भी discussion हुई, बहुत सारी. People have written articles on notwithstanding also. That has been replaced by irrespective. Let us see how the courts take it. But that has been replaced. Other terms which are old words, Latin words which are there in the earlier bill have not been included. Procedural aspects को remove करके हम rules में ले गए हैं. 144B में देखेंगे, 144B में subsection 2 में I think 24 clauses are there. They are faceless. They were put on the statute, but the faceless, heart of faceless has been kept on the statute. The procedural part has been taken to the rules. So that change is also there. You'll see the change. Once you read the bill, you'll see that it is very much more readable at this point of time. फिर old act में there is hardly usage of any formula. As reduced by an amount which has the same proportion of the amount received and amount not received. But there is so complexity in the whole reading. जब मैं formula को text में लिखने की कोशिश करता हूँ, मैं अपने आप को ही confuse कर लेता हूँ. Why not use a formula? I don't know why we did not use a formula till this point of time. There is an extensive usage of formulas in the present suggested bill. ताकि एक formula बनाया, उसके आगे लिख दिया, this constitutes this means this means. It makes it far more readable. Computation of interest, how do you compute your advance tax? Everything is in formula matters now. So you will see it is far more easier to comprehend. Target ये था कि layman भी समझ सके. वो target तो I don't know whether we'll ever be able to meet in income tax or not, but an attempt has been made कि it is just common class 5, class 6 की English. उसी में लिख पाए हम इसको. Let us see how it develops further. Then the major concept of tax year. Assessment year, previous year, आप advance tax भर रहे हैं. Common आदमी को सोचें, you are learned, erudite professionals. But think about the common man who earns only salary. उसने अपना tax देना है online जाके. उसको पता भी नहीं है previous year और assessment year का फ़र्क क्या है. So that was removed and replaced by tax year. So entirely, in entirety, it required a lot of focus on the provisions because हमारी timelines बहुत जगह पर assessment year से run करती हैं, कहीं पर previous year से run करती हैं. उन timelines को change करना, redraft करना, जब tax year बन गया वो assessment year. तो उस context में भी वो change एक major change है act के अंदर. और जैसे मैंने कहा कि why was this bill successful? Why were we successful in getting it over the legal hurdle or the hurdle of actually putting it into the parliament? Was that no policy change is there. बहुत ही माइनर हैं नो आई एम रॉन्ग इन सेइंग देयर इज नो देयर आर सम फॉर रैशनलाइजेशन दैट इज व्हाट वी कॉल इट देयर इज नो सब्सटैंटिव पॉलिसी चेंज कि मैंने एसेट्स को ही टैक्स कर दिया कि मैंने एनपीओज में ही टैक्स लगा दिया ऐसा कुछ नहीं किया हमने सिर्फ उसी लैंग्वेज को उठा के रीड्राफ्ट करके सिंपलर लैंग्वेज में टेकिंग केयर टू दिस एक्सटेंट के कुछ मिस तो नहीं कर रहे जो सिलेक्ट कमेटी की डेलिब्रेशंस हुई आप में से भी बहुत लोग रिप्रेजेंट किया होगा सिलेक्ट कमेटी को यू वुड हैव गॉन देयर एंड रिप्रेजेंटेड एंड देयर इज सो मच लिटरेचर विच इज बीन रिटन ऑन द मीडिया ऑन दिस दैट व्हाट इज दिस इज मिसिंग एक एटीएम मिस हो गया था हमारे पास एक सेक्शन में न्यू रिजीम में उसी के लिए हमें डे 3 से ही आने लग गया था नेचुरली देयर वर सम मिसेस बट इट वाज नॉट intentional miss from that point of time. We tried to put in whatever was possible from the old provisions to the new drafted bill. Now I'll give just 3 basic examples कि simplification किस तरह से run की in the whole process. You see the existing chapter on non-profit organizations. The provisions relating to these entities are spread out across sections, spread out across chapters, scattered throughout the act. एक प्रोविजन एग्जाम्पशन वाले चैप्टर में है एक डेफिनेशंस वाले में चैरिटेबल पर्पस लिखा हुआ है उसके बाद 80G वाला प्रोविजन चैप्टर 6A में चले जाता है टैक्सेबिलिटी एनोनिमस की जो है डोनेशन की वो कहीं और पड़ी हुई है उसकी एक्रेडिटेड इनकम पे कितना टैक्स होना है ये कहीं और पड़ा हुआ है और पेनल्टीज तो अलग हैं ही हैं. So they are totally scattered everywhere. So one basic thing which was done was that it was put in one chapter. सारा कुछ उसकी definitions, उसकी approvals, उसकी terminologies, वो सब को concentrate करके एक ही जगह डाल दिया. Cross referencing बहुत जगह पर थी. इनफैक्ट 1023C एग्जाम्पशन वाले चैप्टर वो लास्ट ईयर ही इनफैक्ट हमने सनसेट किया कि 1023C विल नाउ नो लॉन्गर अप्लाई एंड एवरीथिंग विल गो टू 12AB दैट वी हैड डन लास्ट ईयर ओनली बट इट वाज स्टिल ऑन द स्टैट्यूट सो दिस ईयर एंड देयर आल्सो टर्मिनोलॉजीज differences between approval and registration and prescribed authority there were so many intricate links between the provisions so those were done away with. और सेक्शन 11 में ही जस्ट सी देयर आर 13 explanations and 16 provisos. अभी एक भी नहीं है. So everything is being done. You read that chapter on NPO. That is an example. That is a prime example of how the language has been simplified. It's been really simplified in that provision and consolidated. Non-profit organization, the term was not used in the old act. But globally NPO ही use होता है. For charitable entities, we were using institution or trust or legal obligation. So many different terminologies, university, educational institution. There were so many terms which were being used. Now the singular term is registered non-profit organization. That is what is intended to be. कि इसका intention अपना profit generate करने का नहीं है. Approval or registration, single term has been used, then provisions have been consolidated, redundant provisions have been removed. So many provisos were redundant. पहले registration 12 में होती 12A में होती थी फिर 12AB में बन गई 12A still continued. बीच में कुछ time 12AA भी operate किया. So those all redundant sections have been removed. Focus on the chapter is a clean reading. Again, in this chapter also, there is a tabulated timeline given for registration. अभी भी आप कोशिश करेंगे पढ़ने की जाके कि मेरे को किस टाइम अप्लाई करना है रजिस्ट्रेशन के लिए. If I am a new entity or if I have to apply for renewal, what is the timeline for seeking that renewal? It is very difficult. But in the new bill, it is absolutely clean. It's been clearly tabulated. कि मेरी obligation compliance की क्या है. To promote compliance, easier reading is very essential. And that is what is being done. Again, there is a substantial reduction in words as this change has occurred. Time limits, as I mentioned, have been tabulated clearly. no new income is proposed to be taxed, and there is no policy change on taxability. So that is the basis of this chapter. So that is how the chapter developed. Exemption section 10 अगर आप देखें, section 10 में 51 clauses है, 50 हैं आज की डेट में, or 51, I don't remember. But it is not 50. It is more than 140. And half of them are actually redundant. अगर 10 sub clause 15 देखेंगे, 15 में further sub clauses हैं. किस nature की income tax होती है, exempt है. और उसमें half the incomes are such which are on loans or advances before 1st of April 2005. वो भी हम carry कर रहे हैं आज तक. So that redundancy has been thoroughly done away with. No explanation provisos are there. Section 10 has been carried to a schedule. और Section 10 में अगर आप देखें 3 तरह की exemptions available होती हैं, कि income पे available होती है, person पे available होती है, या other available होती है. तो उन सारों को अलग-अलग schedule बना दिया है. And a specific schedule for IFSCA type entities, that all exemptions related to IFSCA gift city are tabulated, go to one single schedule. So this rationalization structuring, our hope is it will make it easier to understand, easier to search for things, easier on the statute itself. Litigation kam hogi ya nahi hogi, I don't know. Select committee asked us this question also. This was also a matter of discussion, that whether it will reduce litigation or not. We don't know at this point of time. But we hope where there is an interpretational issue, interpretational issues will be lesser as we proceed further. Basic principles are the same in redrafting across sections, that we've tried to reduce the words, redundancy has been removed, tabulation wherever possible, and easier understanding, splitting into clauses, smaller sentences. The chapter on profits and gains on business. Again the chapter has myriad of sections which are specific and again spread out. इंश्योरेंस का सेक्शन एक जगह एक अपीयर हो रहा है, फिर 4 सेक्शन छोड़ के फिर दूसरी तरह की इंश्योरेंस का एक्सपेंस है वो वहां अपीयर हो रहा है. I don't blame the persons who bringing it at the point of change, but unfortunately what has come out is a difficult, unreadable act at this point of time. They've been consolidated. They've been consolidated and made simpler, easier. Formula based in business profession also you will see clear-cut indication on how formulas have been used. कुछ provisions को similar मान के उनको aggregate कर दिया. उसमें problem भी आई हमें. अगर आप MAT वाली provision देखें, there have been criticism on that also. AMT and MAT have been placed in one table. So there is some criticism on that there is some ambiguity which is coming in. If there is ambiguity, certainly it will change. So those things, an attempt has been made to make it as simple as possible. On the basis of the select committee report, we'll again go to the whole process again. And on the stakeholder, the good thing about this government is it is very sensitive about stakeholder feedback. और जैसे ही हमारे पास कोई feedback आता है, हम उसको modify करने में we do not hesitate to modify anything which is based on stakeholder feedback. And that is a fundamental concept which this government has taken, at least on the tax perspective, in the last 10 years or so. TDS, TCS, if you've anybody seen, in fact, I would just like to share. This is fundamentally from where it all started. At a very high level meeting, the chair remarked that आपके 100 पेज हैं TDS के. There are 100 pages which are relating to TDS. इसको कम नहीं कर सकते, payments को aggregate नहीं कर सकते हम क्या? So we said we'll try and to rephrase the sections and all. नहीं, उन्होंने कहा कि आप कहते ही हैं, करते तो हैं नहीं. So that is where the commitment came, and commitment was required and it was made. And finally, what happened in TDS, if you see the chapter, the whole chapter has been basically from the per point of view of deduction, it is only one section, 393. And 393 has 3 tables. अगर TDS किसी ने पढ़ा है तो उसमें आप जानेंगे TDS 3 तरह का होता है, एक रेजिडेंट पे, एक नॉन रेजिडेंट पे, एक एनी पर्सन पे. If you go through the sections, that is the structure what is there. Residents का एक टेबल है, नॉन रेजिडेंट्स का एक टेबल है, और which applies to all persons is the third table in that one section itself. And that's if the table is in itself very clear. ये nature of payment है, ये threshold है, ये rate है, ये payee है. और क्या होता है किसी भी TDS provision में? So if I can read it so simply, why not put it so? So that is exactly what has been done. It's been structured in such a manner that it will be easier to read, easier to get to the finality of things. अगर आप non-resident हैं और आप 194 LBC आपने ढूंढना है तो कहाँ जाके ढूंढेंगे, और वो payments आज valid हैं कि नहीं? That is also a question. So everything now it is clear. If I am a non-resident, I have to focus on one table itself and nothing else. Again, the procedural part also, TCS का अलग था, TDS का अलग था, वो भी सबको consolidate करके एक ही जगह पर ले आए. So everything has been consolidated from the point of view of a simple reader who does not know. That is our focus. Now the outcome. This is one section, this is some section at random I have picked up. We can try to read this section. I'll read it, then I'll read the redrafted portion also. Just to actually impress upon you कि कुछ change हुआ है कि नहीं. Because बहुत जगह ये भी criticism हो रहा है कि कुछ तो किया नहीं है, वही तो है. I'll read it, then I'll read the revised portion. If it appears to the central government that any person to whom immunity has been tendered under this section has not complied with the condition on which the tender was made, or is willfully concealing anything, or is giving false evidence, the central government may record a finding to that effect, and thereupon the immunity shall be deemed to have been withdrawn, and any such person may be tried for the offence in respect of which the tender of immunity was made, or for any other offence of which he appears to have been guilty in connection with the same matter, and shall also become liable to imposition of any penalty under this act to which he would have otherwise been liable. एक रीडिंग में तो हमें क्लियर नहीं होता कि ये क्या कहना चाह रहा है. The change structure. This is the revised provision now. और ये मुझे पढ़ने की भी जरूरत नहीं है. तो सामने दिख रहा है कि 3 कंडीशंस हैं और क्या होगा. Through the act this has been implemented. Throughout, आप जितनी भी प्रोविजन खोल के देखेंगे, यही स्ट्रक्चर इसी तरह से चेंज हुआ है. It is a lot of effort has gone in. It looks कि apparently बहुत ज़्यादा नहीं है, पर जब हम 5 लाख वर्ड्स को स्कैन करते हैं, सेक्शंस देखते हैं और उनको फिर सिंप्लीफाई करने की कोशिश करते हैं, तो इट रिक्वायर्स एन एफर्ट. द लास्ट पार्ट, जिसने भी इनकम टैक्स एक्ट पढ़ा है उसको लगता है कि कोई डेफिनेशन कहीं है, कोई डेफिनेशन कहीं पड़ी हुई है. अकाउंटेंट की डेफिनेशन 288 में होने का कोई पर्पस नहीं था. Why was it lying there? I don't know. Which has to be used throughout the bill. It should be there in section 2. So वो definitions को हमने as far as possible section 2 में consolidate कर दी. कुछ definitions जो सिर्फ उस section को pertain करती हैं या उसी clause को pertain करती हैं, वो उसके नीचे note form में दे दी for the purposes of this section. So that also is a major change which will improve कि अगर मैंने कुछ देखना है तो definitions में ही देखूंगा. Fundamentally it is placed in the definition part only. So I am close to the end of my presentation. I know there will be some questions after the subsequent speaker has spoken. We are happy to answer those, but my request is, from the perspective of reading the bill, try to read it often, because अभी bill बनने में, bill को act बनने में शायद 1 महीना, a bit more maybe. So if anything is pointed out at this stage to the government has already got a lot of feedback. But if anything else comes up, it can always be considered constructively. But an effort has been made, and we are very hopeful that this effort will result in a positive impact, better understanding, clearer interpretation of the hardest thing to understand, which is income tax, as Albert Einstein said, Madam had pointed out during her speech. So that's about it from me. Thank you so much.
Thank you, Mr. Raman Chopra, for sharing your journey undertaken in this painful process of simplification of the new income tax bill. I now call upon Mr. K.K. Chaitanya, Senior Advocate, to share his inputs on the new income tax bill.
थोड़ा आगे कर लो ना, क्लियर दिखिए थोड़ा सा, just push a little bit, then you can push chair itself, then you can have clear vision.
The Honorable Vice President, can you hear me, sir? The Honorable Vice President on the dais, the Senior Counsel, Mr. Saurabh Sopakar, Mr. Raman Chopra, other Honorable Vice Presidents who are present here, Honorable members of the Tribunal, and my dear learned friends. I will have to immensely thank this august body for giving this unique opportunity to spend some time in going through some nice aspects of the direct taxes bill of 2025, which but for this opportunity, I wouldn't have spent so much time, and critically analyze some of these provisions, which, but for this opportunity, wouldn't have been possible, for which reason I shall remain thankful. Secondly, I'm also excited to have the presence of Mr. Raman Chopra on the revenue side, who spoke about the genuine efforts which the income tax department has taken to bring out this mammoth exercise. I'm happier because some of these aspects which I would be presenting now, he would be there to take the same into consideration and possibly, if considered fit, implement as the bill becomes the enactment. I have about 40+ minutes of time, and I'm sure you would appreciate that the income tax bill being so big, it would be a Herculean task, rather impossible for me to be covering all the topics. So I would essentially focus on some critical aspects, starting with some vital changes which Mr. Raman Chopra has explained, and in getting into more particularly the appeal provisions, because I've been told to focus some part of my lecture on the appeal provisions. Then I'd move into some other aspects which would deal with the subtle changes. I'm happy to note from Mr. Raman Chopra's presentation that there is no policy shift, which will make me think that should we point out any provisions which indicate some sort of a shift in the policy, the revenue would have an open heart to correct it. And we lawyers tend to be super technical, so I will have to kindly seek your forgiveness in case I tend to be highly technical, but then at times to drive home the aspect which will have to drive home, then we don't have a choice but to be technical. But I will not have to bug you for more than 40 minutes. I'll put my alarm clock on. 40 minutes, it will start ringing, I'll stop. And within this time, whatever I could address, I'll try to address. Now, the introduction part, I will skip, except stating that they have constituted about 31 members select committee, which to some places, they had an occasion to come to Bangalore, and I had the privilege of making some presentation before them. We have also given in writing our comments, which we expect them to critically consider. We expect the report to be out in the 3rd or 4th week of July, which Mr. Raman Chopra will have to confirm. Then we know the history of Direct Taxes Code of 2010. Then an attempt was made to develop it further into 2013 Direct Tax Code, which didn't take it forward. Now, before I get into the specifics, these are the stated objects of the bill. To make the law simple, it has to be appreciated that genuine efforts have in fact taken place to make the law simple. We will also have an occasion to see where is law really made simple, in addition to what Mr. Raman Chopra spoke about. To make the law straightforward, this will have to see as to how far the law is really made straightforward. To minimize litigation, so we have lawyers here on one side, the engineers, taxpayers on the other side, we have the judges on the other side. And in the country like ours, to expect the litigation to be minimized would be something which is too much to ask for. To remove the redundant provisions, yes, several of redundant provisions have been removed. And the salient features are the changes which, as practitioners, which we could notice could be these. The language has been simplified to the extent possible. But mind you, the oversimplification of language could land us in trouble, which I will demonstrate how. See, end of the day, we are not considering a story to be told. We are considering a law to be followed and implemented. So it cannot be oversimplified. It cannot fall short of what it is expected to state. If it falls short, then the courts will have to fill the same in. That becomes difficult. And again, an effort in interpretation. The welcome change which Mr. Raman Chopra explained, the larger texts at places have been converted into tables. For example, we will have section 19 of the bill, which will give you a table of all the benefits which a salaried employee would get. That's a welcome change. You will have section 393, which will have a table of TDS. So they have really taken an effort to make TDS less tedious in terms of putting a table beneath section 393. Then the provisions which stood scattered at various places, like take the case of a charitable trust, which Mr. Raman Chopra explained. You have section 1023C at one place, you have 11 to 13A at another place, you'll have 115 BBC at some other place, 115 BB F, G, etc. coming at a much later place. So they were all quite scattered. Now you have all the provisions relating to charitable trusts are being captured in chapter 17b. You'll have association of persons, a body of individuals. We had the complex provisions handling it, sections being scattered at various places. Now you would find them all captured in chapter 17, part A, subpart 4. So like this, changes have been brought in. Now the provisos and explanations have been converted into subsections. Mr. Raman Chopra mentioned it more than once. Now, whether it's good or bad is something which I would not state at this point in time. I will take you through some cases where the provisos have been converted into subsections and what is the impact. Explanations have been converted into subsections, what is the impact. Then you would be in a position to better judge as to whether these ought to have remained as provisos and explanations or they rightly translated into subsections. Because a proviso and an explanation has its own role to play. A subsection or the principal section has its own role to play. An indiscriminate conversion of a proviso and an explanation to subclasses could land us in trouble, which I'll try to demonstrate, which is basically to be not seen as criticizing the effort. We all admire that enormous efforts have gone in, but the objective is at the bill stage we'll have to critically analyze so that the revenue is open to consider the stakeholders' views, and we are here to give what the stakeholders' views are in the fond hope that these are not necessarily to be accepted, at least to be critically considered. Then you'll have notwithstanding to be replaced by irrespective of. What it would mean, how has the court looked at it, is something which needs to be looked upon. Then the redundant provisions have been removed, a very, very welcome measure. And the provisions have been more serially numbered, continuously numbered, unlike the existing Income Tax Act. Obviously, in the Income Tax Act of 1961, you have the legacy issue. Act was born way back, and it lived throughout, and it has been quite like mature in terms of having been handled by hundreds of judges. Thousands of advocates have argued on this. So it has reached some level of maturity. Why I'm saying that it has reached some level of maturity is not to discard 1961 Act. As you move into the new Act, take from the 1961 Act all the takeaways. The mature part of the Income Tax Act of 1961 will have to be necessarily incorporated in the 2025 Act so that we don't reinvent the wheel of litigation. That's the whole objective. Then you will have the logical links have been brought in. Act is geared up to go for the smooth progression, and you will have formula-based approach. Like, for example, you will have the WDV, 43.6 read with about 8 explanations, would make it very complex to figure out how the WDV will have to be computed for the purpose of depreciation. We will have now section 41, which contains a very simple formula, which is less litigation prone, and therefore this has to be considered as a really welcome move. With this, now we will move into the real aspects of the Income Tax Bill of 2025. Now, explanations have been converted into subsections. Let me take you some of the cases where how it could create some issues. And before this, as I've said earlier, explanations and the provisos being part of a section is like a big Hindu undivided family. So they'll have their respective roles to play. You'll have a karta, the main body of the section. You will have the co-parceners, the subsections. You'll have explanations and the provisos like the minors, etc. So they will all work in tandem. The moment the family split, the kind of control which the karta would have had on all the members would no longer be exercised. The split families would become independent. When they become independent, they could compete with you. When they compete with you, and when you reduce it in the form of a law, you will have difficulty in implementation. Let's see how it works this way. Consider an example of Section 6, subsection 1, capital A of the Income Tax Act. Stateless citizen. In terms of various BEPS action plans, it is expected that we shouldn't have a situation where a person who is a citizen of a country would act like a nomad and become non-resident everywhere and would end up paying no tax in any country. This is something which is undesirable. In line with this action plan, Section 6, subsection 1A of the Income Tax Act of 1961 has been brought in, which will make a citizen of India with Indian income exceeding 15 lakh of rupees, but not being a resident in any other country by reason of being liable to tax, would be regarded and deemed to be a resident in India, 6.1a. But there is an explanation to 6.1a which stated that, look, if you're already a resident under section 6.1 in terms of 182 plus days or whatever, this deeming fiction will not apply to you because you are per se a resident. We don't have to deem you. Then we have section 6.7 which will call this person who is called a deemed resident, a stateless person who is deemed to be a resident as a not ordinary resident. So what section 6.7 said is, look, if you are a person covered under 6.1a, thereby you would become a resident, we would not make you an ordinary resident, we will call you a not ordinary resident. All this was working fine because you had 6.1a, you had an explanation which is subservient to 6.1a, then you had 6.7 which applied to whole of 6.1a read with the explanation. This is how it worked very fine. Now you know what has happened. What was 6.1a is now taken as section 6.7 in the bill. What was explanation to 6.1a has now become 6.8 in the bill. So they become separate, family split. And what is 6.13, which is corresponding to 6.7 of the Income Tax Act, which would say if you come under 6.1a, we will call you an NOR. That subsection of section 6.13 would only refer to 6.7 but would not refer to 6.8. Which will mean what? All of us who are residents who would have our Indian income exceeding 15 lakh can now claim to be not ordinary resident. This is because section 6.13 of the bill would only make a reference to 6.7 and it's forgotten that 6.7, one splinter part of 6.7 which is now sitting as 6.8 is not referred to. What I'm trying to say is, when you redraft the law, you'll have to take extreme care. An explanation which worked as subservient to 6.1a when it is made independent, when you redraft and put section 6 within brackets 13, you will have to also make a reference to 6.8 as well. I'll take you to some other examples. You may be aware of the business connection under section 911, explanation 2, which is agency permanent establishment, which you'll find in Article 7 of the treaty. We have the domestic version of it called agency business connection. And you are aware that not every dependent agent would trigger business connection. In order that a dependent agent triggers business connection, he has to carry out one or more of the prohibited activities. It is, he has or he habitually exercises an authority to conclude contracts, or he habitually holds stocks for non-resident and regularly delivers goods, or he habitually secures orders to the non-resident. A mere dependent agent wouldn't trigger your business connection. He would trigger your business connection if he were to carry out one or more of the prohibited activities. Now, how are all these contained in the present statute? You have explanation 2 to section 911. Then you have the provisos thereunder. When read together, this would have been what is conveyed. Now, section 9, subsection 8, clause B of the bill is cut into multiple clauses. And each clause deals with one situation. I would not take you through all this highly technically, but I'll explain you what it has caused. Now, a close reading of this would cause a situation where an independent agent in any way will not trigger you business connection. Not to worry about it, even in the bill. But a dependent agent under the Act would have caused a business connection if and only if he carried one or more of the prohibited activities, which I explained. But whereas a reading of the bill would suggest that a dependent agent to cause a business connection need not carry out the prohibited activity. This cannot have been the intention. This is a serious flaw that has crept into, wouldn't have been intended. Now, there are so many agents who are dependent on us. He could be a marketing agent, he could be a procurement agent, but he may not be concluding contract for me. He may not be holding stocks for me. He may not be securing orders for me. Law would not expect those persons to be regarded as causing business connection to the non-resident. However, the way these clauses are structured would now make every dependent agent, no matter what he does, as causing the business connection. So this is the dangerous aspect of explanation and proviso being simply converted into independent clauses. Now let's look at the provisos. Provisos also are converted into independent clauses. Some places they have taken care to ensure that no harm is created. Efforts are made. Some places these efforts are found lacking. Let me explain both. You will have the case of an unrecognized provident fund being converted into recognized provident fund, and you'll have concept of transferred balance. You'll have Schedule 4, Rule 11, Sub-Rule 4 with a proviso which will mandate the assessing officer to compute the taxable part of the transferred balance when your unrecognized provident fund is converted into recognized provident fund. Now this Rule 11.4, which was read with a proviso, is now cut into two clauses. In the new bill, it has become 11.4 and 11.5. What was 11.4 with a proviso in the present act has become 11.4 and 11.5. But then, when they make appropriate reference to Section 7 of the Income Tax Act, which will provide for income deemed to be received, they have made a reference not only to 11.4 but also to 11.5, because they are mindful that what was 11.4 read with a proviso has now become 11.4 and 11.5, and appropriate reference has been made. This is the care that ought to have been taken in all cases where the explanations and the provisos have been converted into subsections. Now let's look at this situation. Very interesting. See, not all these situations need necessarily benefit revenue. It's either side. The kind of proviso being converted into subclause in the context of income from other sources is now giving an unintended benefit to taxpayer. Let me explain how. You are aware of dividend income, which is to be charged to tax under 56 to clause A. You will have Section 57, which will provide various deductions in computing income from other sources. Then you will have for dividend income, there are multiple provisos to Section 57, which will bar any deduction except interest, the two not exceeding 20% of the dividend income. So you won't get any deduction under the present dispensation. If you are having dividend income chargeable to tax, you don't get any deduction except interest, the two not unlimited, interest not exceeding 20% of your dividend. How is this structured? This is structured by way of Section 57 read with provisos. Now, this has been now split into two subsections, 93.1 and 93.2. So 93.1 inter alia applies to dividend and will give you all deductions. 93.2 says, in respect of dividend, deduction on interest shall not exceed 20%, but 93.2 does not override 93.1. Now, as a taxpayer or as a counsel for the taxpayer, I am going to advise that they stand independent. Now, it's a partition family. One family does not owe an explanation to another family. There is no interlinking. 93.2 would not say irrespective of or notwithstanding anything contained in 93.1. As a result whereof, this kind of conversion of proviso into subsection has resulted in an unintended benefit to the taxpayer. So these are the finer needs, finer aspects that need to be understood. Now, irrespective of has been used. in the place of notwithstanding. At some places, apart from substituting notwithstanding by the word irrespective of, they have also used another phrase called regardless. For example, in section 356, subsection 3, clause B, which will deal with transfer of an appeal from JCIT appeals to CIT appeals, instead of using irrespective of, regardless of has been used. So an extra term has come. Now leave that out. In some places, as we have seen, irrespective of used even when it is not required. I'll give an example. You go to section 252 capital A. That would deal with the qualification of the ITAT members. That had to override 252.2 and 252.2a because it had the earlier provisions. Then you'll have the Tribunal Reforms Act of 2021, etc. As a result whereof that to bring in a separate section called 252a, which had to necessarily override 252 because it had contra provisions there. But in the IT bill, there is no such contra provision, so section 361 subsection 2 would nonetheless use irrespective of. There is nothing to be overriding there. That remains. Nonetheless, the new bill uses irrespective. So you have to be mindful when you use the word irrespective. We can't be using it irrespective of whether there is a need for irrespective of. Now, one may ask, irrespective of isn't greatly different from notwithstanding. There is an authority on this from the Honorable Supreme Court in R.S. Raghunatha versus State of Karnataka, where irrespective of would render the referred provision completely OTOs, whereas notwithstanding would not render the referred provision OTOs, it would render the referred provision OTOs only to the extent of repugnancy. This has to be extremely carefully understood. So we are not going to do any great thing by simply replacing notwithstanding by irrespective. It's not going to reduce the number of words or the length of the act. But there will be hundreds of cases coming up then. People like us will start interpreting what is irrespective of, what is notwithstanding. So you've got to be careful when you would, choose a different word as against a more mature word which has received the appreciation from the courts all along. Otherwise, you'll have, a lot of issues. Now, when it comes to reassessment, I'll give an example where irrespective has been just like that used. You'll have section 283 of the bill which corresponds to section 150 of the Income Tax Act. What is 150? It's an assessment which involves computation, recomputation to give effect to or in consequence of a finding or direction given by any court, either under Income Tax Act or under any law for time being in force. And 150, section 150, would permit the assessing officer to proceed with the reassessment, notwithstanding the time limit contained in section 149. So what has 150 to do with? It has to only override the time limitation of 149. But it should not override the other jurisdictional aspects, meaning there has to be in the first case an income escaping assessment. There has to be a case of issue of notice. If the issue of notice would predicate a prior approval, the prior approval will have to be taken. So these are all the jurisdictional requirements because you're not dealing with assessment, you're dealing with reassessment. The two, you're dealing with reassessment which will have no time limit. So extra caution has to be taken. Now, section 283 here in the Income Tax Act, the Income Tax Bill of 2025 would not only override 282, it would also override section 280 which corresponds to the situations where approvals will have to be taken. You are aware that in the reassessment, you have two schemes. One is under such. Leave that out, that is now becoming part of the block. Now, rest of the reassessments are categorized into 148A category, direct notice under 148 category. So direct notice under 148 category would require the prior approval of the specified authority. So that has been now gone for the reason that there is an incorrect writing of irrespective of over to even section 280 of the Income Tax Act, Income Tax Bill, which will require a prior approval. So you have to be extremely careful here as it would go on. Now, I have just illustrated a few of the cases. There could be far many where a simpliciter conversion of explanations and provisos into subsections, a simpliciter substitution of notwithstanding by irrespective of without seeing the impact that it causes, will create issues and would be prone to litigation. So with this aspect, now I'll move to the next topic because I have a lot other to discuss. But then I've been asked to focus firstly on the appeal provisions, considering that the August gathering here would largely represent the honorable judges of the tribunal. So let me spend some time on the appeal provisions before I go to other aspects. Now I have only dealt with two segments of appeal here for the paucity of time, the CIT appeals and the JCIT appeals and the Income Tax Appellate Tribunal. Let me deal with the first appeal now. Section 356 corresponds to 246, that is appeal before the JCIT appeals. Now, 356 subsection 6 will permit board to make whole of 356 inapplicable in such cases or class of cases. We have similar provision in 246 subsection 6, which empowered board to create exceptions, but it applied only to 246 subsection 1. It did not apply to rest of subsections. You may ask, what is the implication? The implication is that the rest of the subsections would deal with some essential aspects like the fairless appeal, then transfer of cases from the JCIT appeals to CIT appeals, etc. If these provisions are not made applicable, then it would give the board the power to move away from fairless appeal, any case, to the jurisdictional appeal, which would then interfere with the superior authority, that is Government of India, which is superior to the CBDT in making a scheme. So that is why the present act rightly restricts the power of the board to interfere only insofar as 246(1) is concerned, not with the subsections. Whereas here, it will enable board to overcome whole of section 356, which would even include the faithless appeals, which I don't think is intended, it may be unintended. Now, there is a serious aspect in enhancement power under section 251, which you have in the present act, which is now contained in section 360 subsection 3. See, section 251 deals with the power of the Commission of Appeals or the Joint Commission of Appeals. There's an explanation to section 251, which says in disposing appeal, the Commission of Appeals or the Joint Commission of Appeals would be entitled to consider and decide any issues arising out of any matters arising out of the proceeding in appeal, irrespective whether the particular matters are raised in appeal or not. This is the plenary power of the Commission of Income Tax Appeals or the JCIT appeals to go for enhancement. But look at the way how it is couched. It is coming in the form of an explanation, meaning it is subordinate to the main provision under 251. What it actually means? It means when the Commission of Appeals or the JCIT appeals, in the course of exercise of his appellate functions, as he would consider and decide an appeal, then he will have the power of enhancement. That is why in the explanation you will find the words in disposing of appeal. In disposing of appeal. In as much as if the learned Commission of Income Tax Appeals has already passed an appellate order, he would become a functus officio. He would not be permitted to then make an enhancement separately. Enhancement power would have gone coterminous with that of the power of the appellate function. This is how beautifully explanation blended itself with the main part of section 251. Now let's see what has happened. In the bill, the power of enhancement is coming separately. So it is not linked to the basic power of execution of appellate function. 2. In subsection 2, which will give subsection 3, which will give this power, the words in disposing of an appeal, these words are omitted. Can you imagine the implication? If I were the CIT appeals, I would have decided an appeal today, and tomorrow I would never become a functus officio insofar as me deciding any other matters not in appeal, because these words in disposing of an appeal are conspicuously missing. It becomes an independent jurisdictional issue then. Is it something that is intended or an error that has crept in? So this would require a lot of introspection. So my humble request to the revenue is, you don't have to do it within 6 months. Now that an enormous effort has been made in bringing out the bill, please allow it to be scrutinized. Take little more time before it becomes the act, because once it becomes an act, then we shouldn't be blaming after 20 years that we have carried out so many amendments which then existing ChatGPT will not recognize. So we'll have to be, we have had the benefit of mistakes, so we shall not be committing the same mistakes again. Now let's go to the case of the tribunal. Insofar as the assessee's appeals are concerned, there is an effort to simplify, because it would state that all the orders passed by the JCIT appeals and the CIT appeals are to be taken to tribunal should the assessee so desire. Unlike in the present dispensation, where in 253(1) small a, small a, where various sections are mentioned, actually referring to all these sections is rightly not required. As long as the learned CIT appeals or the JCIT appeals passes an order with which as an assessee I am aggrieved, I have the ability to take it in appeal before the Honorable Tribunal. However, as they tried to do it, in 362 subsection 1 clause B subclause 1, they have made a case of allotment of provisional registration to a charitable trust as appealable, which is totally not necessary, because the department doesn't have a choice for the provisional registration. It has to necessarily grant. For 3 years it has to grant. Having granted, it has the ability to withdraw it later on. But once an application for the provisional registration is made, the revenue has no say on anything except allotting it for 3 years. So therefore the question of we take it in appeal before the tribunal would not arise. This clause, in my humble opinion, may not be necessary. Now, now let's come to the departmental appeals that could be taken to the tribunal. Earlier, law was very clear. It stated that the orders passed by the CIT appeal or the JCIT appeals, either under section 250 or under 154, the rectification orders by the appellate commissioners. If the department is aggrieved, they can take it in appeal. So the orders that are passed under 250, the orders that are passed under 154, amending the orders under 250, right? These are the appealable orders. But then there is a change in law in the bill. They say orders passed by the JCIT appeals and the CIT appeals under the Act are appealable. Under the Act are appealable, not under section 250 or 154. What do you mean by under the Act? You may know that the CIT appeals and the JCIT appeals have the plenary power of levy of penalty. Now let us take a case where the CIT appeal would levy penalty for underreporting. Can the principal commissioner say that I am not happy with the order of penalty and underreporting? It's a case of misreporting and hence I will take it in appeal to the tribunal? Because that is an order passed. Likewise, the CIT appeal may initiate penalty in respect of certain offense, and I would bring in 273B kind of a situation of reasonable cause. So he's happy with that and he'll pass an order dropping the penalty, which also is an order. Then the Act says, the bill says, any order passed under the Act could now be appealed if the principal commissioner is aggrieved. I don't think this is the intention, but if this is allowed to stay in the Act, this could be the case. Therefore, enough of care has to be taken to limit the ability of the department to take an appeal. As it is, 70% of the appeals don't emanate from the taxpayers, it emanates from the revenue. Revenue is the biggest litigant. So therefore, allowing the revenue to take in appeal in respect of any order passed by the CIT appeal under the Act is something which is not intended. Now the fairless ITAT appeal mechanism, there are explicit provisions in section 253 and in section 255. You don't find those provisions in the bill, but you will not have to wonder why are they missing, because there's an omnibus provision under section 532 of the bill, which will provide the central government to issue fairless in respect of any of the functions under the Act. Now, one another uncalled for change, which affects the power of the learned tribunal for amending its order under 254(2). So as section 254(2) presently stands, the way I understand is that two types of amendments are permissible. One where the learned tribunal finds itself that there is an error, then it may amend the order within 6 months. Alternatively, or concurrently, if the other party, department or the assessee, brings such error to the notice of the learned tribunal shall correct it. This is how presently section 254(2) is structured. Meaning there are two types of amendments: suo motu amendment, amendment at the instance of the other party. Now section 363 subsection 2. My time is up. Sir, how much time do I have?
Carry on 5-10 minutes.
Are you okay for 5 more minutes?
5 more minutes. Interesting.
With the permission of the chair, I'll take 5 more minutes. Now, section 363 subsection 2 appears to take away the ability of the learned tribunal to do the suo motu amendment. It seems to deal only with the amendment if such amendment is brought to the notice of the tribunal by the party. Now, one may ask me, would the tribunal not have the inherent power of correcting an error if it is so apparent on the face of it? You have the decision of the Constitutional Bench in Brijlal's case, the Honorable Supreme Court. Dealing with the case of Settlement Commission, the Supreme Court says Settlement Commission is like ITAT, whereas ITAT is enabled to amend its orders under 254(2), the Settlement Commission doesn't have power, and therefore the Supreme Court Constitutional Bench had to say Settlement Commission wouldn't have the power of amending its order. Then they had to bring in 245D, subsection 6, capital B. Now look at this. So, of course, we have the decision of Supreme Court in Honda Seal's case in 295 ATR 466. Saurashtra Kutch case, we have decisions to say that it is not right to have an error to continue if the error is noticed. So, tribunal may have the inherent power, no doubt. But why do you take away an existing power and cause conflicts? Then we'll have the power of stay. You will have section 254(2)(a) in the form of 3 provisos that would deal with the power of tribunal to grant stay. This power is otherwise inherent. Mohammed Kunni's case, Supreme Court has said. Now they have codified it in the form of 3 provisos. So first proviso will deal with grant of stay. Second proviso would deal with extension of stay. Third proviso would deal with no more extension beyond 365 days, even if the appeal is not disposed, not due to the delay from the assessee's end. So this is how it is structured. Now, this is very well structured. There's not much of a room for the debate. But then the way it is couched here is that the words in any case, it shall not exceed 365 days. These are the words that are found in third proviso, is now missing. Now missing. Therefore, it is now open to an assessee to argue and for the learned tribunal to consider, of course, arguably, that whether the stay could be granted even beyond 365 days. So there is something which, would unnecessarily create these problems, could have been avoided had the language of existing act been retained. Now, there are so many other things, I'll not get to it now. I will share this PPT so that those who have time and are interested in looking at it may kindly see it, except with one thing with which I'll conclude. That is use of as per in place of in accordance with. It's absolutely fine by itself, no difficulty. But then look at section 4 of the Income Tax Act. Look at section 4 of the Income Tax Act, which is the pillar of the Income Tax Act. Lot of care ought to be taken when you draft a section like section 4. Look at present section. It says, in accordance with, comma, and subject to the provisions. Please note these carefully. In accordance with and subject to the provisions. Now in the new dispensation, they have had as per, which will take care of in accordance with, but it not take care of subject to. So meaning section 4 now is not subject to provisions of Income Tax Act. What would it imply? If you go to section like section 90, look at Ajadi Bachao Andolan's case. They have said that section 90 is subservient to section 5 and 4 because section 4 and 5 are subject to the Income Tax Act, of the other provisions of the Income Tax Act, which inter alia include section 90. Now we will have the word subject to grossly missing in whole of section 4. Would that mean that if I have other provisions in the Income Tax Act where I am eligible to pay tax at lower rates, those lower rates have now to be ignored? The answer is definitely no. So therefore, my humble request to the revenue, with this I'll conclude, that please don't consider me as being overcritical of these provisions. These have been done with genuine concern, being a practitioner in the tax for decades, and also hoping to be there for a few more decades. And therefore, kindly consider this as well as other suggestions from the stakeholders, put it to clinical examination before converting this piece into a part of statute. With this, I would immensely thank you all for having very patiently heard me. There are a lot of other things to discuss, which we'll discuss in a different occasion. Thank you very much.
Thank you, Mr. Chaitanya, for sharing your thoughts. So I now request Mr. Saparkar to summarize the contents of the speech given by our respective speakers.
We are running out of time. In fact, we have run out of time, so I'll be very quick. Shri Chopra took us to the journey and explained as to why we were required to amend or bring in the whole new law. Reformation is the key. Simplification is what the requirement is. Conciseness, lucidity, and easy to read. Drafting is meant for the benefit of common people, laymen, and idea was to collate information at one place. I cannot join an issue with him on that. So far as Mr. Chaitanya is concerned, he, like a skillful surgeon, went through some of the provision in an incisive manner and explained the problems that we are likely to face. And I can do no better than to say that he has done it in an excellent manner. Let me take maybe less than 5 minutes to add some flavor to what he has said. I would not reiterate his concerns, but I would now give what my perspective is. And the problem is this: with elimination of every proviso, with elimination of every explanation, with elimination of every notwithstanding, whether the judgments rendered under the present regime would continue to hold field. Please see, in the morning we looked into the provision. The simplest possible word in English is Delhi High Court interpreted in one manner, Honorable Supreme Court interpreted in another manner. Now, explanations and provisos have always been taken to be subservient to the main provision. Proviso, if it has something which is of a procedural nature, it is held to be retroactive, retrospective. If proviso is of a substantive nature, it is always to be taken as prospective in nature. Now provisos are converted into subsections, and therefore fertile mind, and I am not saying only SSCs or only the revenue, would argue to undo the judgments which have been rendered even by the Supreme Court by saying, yes, this is what the Honorable Supreme Court said under the old law, but under the old law, the language was this. Now the language has undergone a change, and therefore the whole thing requires a relook, which would mean that law which has been settled by the Honorable Supreme Court of India, maybe again litigation will start for no rhyme or reason. As revenue makes it very clear, we have no desire to change the tenor of law. We only want to simplify it, and yet in the process, a big Pandora's box is likely to be opened. If there is a judgment in favor of SSC, I would not really blame an assessing officer trying to not give the benefit or deny benefit to SSC by saying now law has undergone a change, or judgments against the SSC sought to be distinguished by the counsels for the SSC saying that old judgment will not continue to hold good. Maybe, and that is one thing that I believe requires some consideration, if the revenue can come up with a circular or a clarification that all old judgments where the law has not undergone a significant change will continue to hold the field, that board circular can obviate or can ensure that lot of unnecessary litigation may not take place. That's one aspect. Second, simplicity. I appreciate the need for simplicity. But then, is it that we need to bring the law so simple to really address a layman? Law is for a layman, but not to be understood or interpreted by layman. Medical textbooks are not written in simple language because they are to be read by the doctors. Law, if you make it too simple, you are likely to create ambiguity, which is likely to create confusion, and either side, revenue or SSC, would then create situations of creating uncertainty. Probably, therefore, in the process of simplifying the law, have we not really taken a path whereby we have sacrificed certainty of the law till today? Was certainty not more important? Third, and probably more important, is this. The law, you don't bring new income tax act in every decade. This is brought in after 6 decades. So if this law is essentially to simplify the law, would there not be reluctance to bring in amendments in the years to come which are of a fundamental nature to suit, to facilitate the economy or the needs of the nation? Are we not, by bringing in a new law only to address the issue of simplification, are we not in a way closing down, if not the gate, windows to bring in amendment for the purpose of larger social, public, economic good? Should it not have addressed every problem instead of only dealing with the simplification? Anyway, as Mr. Chaitanya says, there are issues and issues. Maybe for that you need a one-day full seminar dealing with every chapter. For example, let me take one simple example. Now, at the time of survey or search, revenue is given a power to enter into and to require SSC to make available computer system, including every software devices, including what that is on the cloud, so on and so forth. There are certain provisions wherein some amendments are also made. So maybe we need one full day seminar. We have had a heavy topic and we have been discussing law. I'll take only one more minute and let me end with little lighter talk. Law is always meant to be logical, or is it logical? There is a story, I hope not true, law versus logic. A professor of logic gave a student F or fail in his examination paper. The student went to the professor and said, "Sir, you must make the grade change. I have to get A grade." The professor said, "You have thoroughly failed. I can't give you A grade. You must leave with F." Student said, "Sir, I ask you a question. If you can answer my question right, I'll go home happy with F. But if you can't answer, please change it to A." Professor said, "Very good." The student said, "Sir, what is legal but not logical?" Legal but not logical. What is logical but not legal? And what is neither legal nor logical? Because we are dealing with law and it is supposed to be logical. The professor went on scratching his head and couldn't come with the answer, and he said, okay, come tomorrow. Next day, student went. Professor had thought for the whole day. Couldn't come up with the answer. So he asked the student, what's the answer? Student said, sir, first convert F into A. So professor converted F into A and said, now give the answer. Sir, you are 60. You are a wife of 30. Legal, but not logical. Your wife of 30 is extremely friendly to a student of who is 20. Logical, but not legal. And that student of 20 had failed in your exam and you just give him A grade, it is neither legal nor logical. Thank you very much.
Thank you, Mr. Saparkar, for ending your speech with a wonderful joke. I now request Mr. Mahavir Singh, Vice President, Delhi Zone, to propose the formal vote of thanks.
Law is simple or complex. This debate will go on, and it is going from centuries, and it will go on further. Brother Bala told one poem. At that point of time, presence was very less for the benefit of all. In any way, advocates or chartered accountants, if litigation increases, they will make money. That is their bread and butter. That poem, a clearer code, clear levy of tax by a simple way. The tax law enters a brighter day. With fairness in form and substance and thoughtful might, it brings old shadows into light. Income defined, no room for doubt. Residency rules now firmly laid out. Digital paths and justice combined, a law for the future, reformed and refined. One more secret for this couplet. This is written by our sister Beena Pillai. It is neither Bala's creation nor mine. Thank you, Saparkar ji. Thank you, Chaitanya ji. Thank you, Chopra ji. Thank you to all for patient hearing. Now tea is waiting, otherwise tea will get cold. Thank you very much.
आगे आ जाए यहाँ आ जाए